Started. There we go. Hang on just a second. Right. We're getting the Facebook Live. All right, there we go.
So does that mean Zoom is running as well? Do we have the participants?
Yeah, well, I'm about to start that part.
Okay.
Here we go. You get to talk. On your mark, get set.
Hello, everyone. We're going to be waiting for a couple of minutes as people join the meeting, and then we'll get things kicked off. I can see the numbers of participants are increasing. So for those of you who have just joined, I'm just letting you know that we're going to wait a couple minutes till that stabilizes, and then we'll get things kicked off.
You might tell people we're putting the agenda in the chat, and we hope everybody can see it there.
Yeah. So let's see, we're a couple minutes into it, and the numbers have gotten pretty stable. So we're going to start in just a minute. I did want everyone to be aware that we've posted the agenda to the chat. So you should be able to see that. My name's David Young. I'll be facilitating tonight, and we're going to be kicking off in just another minute or so. All right, it looks like the numbers have been pretty stable. Looks like we have about 140 participants. I'm going to go ahead and kick things off. Here at NOAA, we try to start on time and end on time, and we'll honor that today. My name's David Young. I'm a member of Brentwood United Methodist Church, and I'm a volunteer with NOAA's Criminal Justice Task Force. It's my honor to be the facilitator for tonight's webinar about courts, judges, and bail. This event is proudly being presented by Nashville Organized for Action and Hope, NOAA. Also, A Voice, Nashville Community Bail Fund, the Community Relations Committee for the Jewish Federation of Nashville and Middle Tennessee, Choosing Justice Initiative, the Interdenominational Ministers Fellowship, the NAACP Nashville Chapter, Nashville Jewish Social Justice Roundtable, the Temple Social Action Committee, Unheard Voices Outreach, Urban League of Middle Tennessee, West End Synagogue Social Action Committee, and the West Nashville Clergy Coalition. I'd like to thank the organizers, Avi Poster, Erwin Vinnick, Jane Borum, and Eugene Sabri. I'd like to thank you all for joining us tonight, for your interest and for your time. Back in 2018, I read Just Mercy by Brian Stevenson, and that really opened my eyes to the power that's held by judges and district attorneys. There are many other books and movies that have highlighted that fact, but I don't know that the public is always sensitive to that. These upcoming elections matter, and they have a huge impact on mass incarceration, pretrial detention, cash bail reform, restorative justice. The judges we elect will hold their positions for 8 years, so we must make the best decisions that we can. We are grateful for our panelists who are generously sharing their time and their expertise with us this evening. First off will be Dawn Diener. She's the executive director of the Choosing Justice Initiative. She was formerly the elected public defender for Davidson County and held that position for 10 years. Before that, she was the assistant public defender in that office. She knows all about the practical realities of judges and courts, but today she's going to take us to school. She'll be covering the theory of how the courts, the judges, the prosecutors, and the defense attorneys work within the criminal justice system. Next presenting is Courtney Teasley. Her firm is Courtney Teasley Law Firm, and she's the legal redress chair for the NAACP Nashville. She's going to reflect on the actual on-the-ground reality of how that criminal justice system works and how the judges and the DA and the bail policies impact people, real people on a day-to-day basis. Erica Perry and Reggie Williams will round out the evening by giving us a view from the perspective of the people who have an encounter with this system. Erica is the executive director of the Nashville Community Bail Fund, and Reggie is someone who has actually experienced going through the court system and the bail system. We've left 20 minutes for questions. Please put those into the chat, and please indicate who you want to direct your question to. Jane Borum will be screening them and will pose them to our esteemed panelists. So with that, I'm going to turn control over to Don Diener.
Thanks so much. And I am going to share my screen. And get started. So my job tonight is to try to provide some basic education on how the Davidson County court system operates, the different kinds of judicial offices that we have, and an overview of how our courts work. Well, for some reason, my PowerPoints are not advancing.
With technology, there's always a surprise.
Here we go. Okay. So what I first want to start with is the big picture. When we talk about
are you sharing your screen again? The PowerPoint, because we don't see it just yet.
Okay. Well, let's give it a go again and see if that works. Thanks, David.
All right, I see something.
Here we go.
Here we go.
All right, great. So the big picture in the criminal court system really starts with who winds up there and how they wind up there. So it begins with the legislature. The state legislature enacts criminal laws, and that's how we end up with people in our criminal courts charged with violations of those laws. Police arrest people. And so they're the ones on the front lines deciding who they believe has violated the law, arresting people, filing charges against them, bringing them into the court system. The court system itself is then comprised of what really looks kind of like, I think, a funnel. The initial entry point for most people into the criminal legal system in Nashville is through General Sessions Court. General Sessions Court is a high volume court. I think in an average year recently, they're going to handle 25 to 26,000 cases are going to come through the General Sessions Courts. Most of the cases that come there are people charged with misdemeanor offenses. So that's something that carries less than a year in jail. Felony cases can also start here. And when they start here, judges are really only deciding probable cause and bail issues. General Sessions judges don't have authority to take guilty pleas on felony cases. Those eventually go to criminal court, which we'll talk about in a minute. So the judges who sit in General Sessions Court do a multitude of things. They take guilty pleas on misdemeanors. They conduct preliminary hearings, which is just language, fancy language for deciding if there's probable cause to believe somebody committed a crime and the person charged is that person. They also conduct bail hearings for individuals generally who've been arrested within the last few days to up to 2 weeks. They conduct what's called bench trials. So if somebody is charged with a misdemeanor, doesn't want to plead guilty, and wants the judge to decide at a trial if they are guilty or not, then the judge would preside over a trial without a jury and make the decision about guilt or innocence. Another thing they do a lot of is probation violation hearings. So if somebody is placed on probation in General Sessions Court, the judges at this level will decide whether or not they have violated probation. And if they have violated probation, whether or not they should go to jail or have some other sanction imposed. The judges at the General Sessions Court level also supervise magistrates who preside over what we call night court. That's the court where people go 24 hours a day, 7 days a week, 365 days a year when they get arrested on a warrant. They're going to go through night court, even though it operates all the time. That's what we call it. They're going to go there for the judge to set bail, typically, and advise them of what the charges are. The General Sessions judges in Nashville, we have 11 of them, and I'll touch on that later, and they rotate among their dockets. So I'll talk about that in a few minutes. Also, criminal courts. So criminal courts, again, you're going to funnel down. They're going to handle, in Davidson County, the criminal court judges, there are 6 of them, are handling anywhere roughly each year from 2,000 to 3,000 cases. So much smaller numbers than we're talking about for General Sessions Court. And most of the cases that go to our criminal courts are felony charges. This is the level of court where jury trials are conducted. So, for instance, there was a well-covered trial a few weeks ago that was a jury trial related to the Waffle House incident, and that was a trial that was conducted in criminal court. Judges in criminal court, rather than rotating through, they each have their own assigned caseload. So once a case goes to a particular judge in criminal court, it's going to generally stay with that judge from beginning to end. Now, the judges in criminal court, in addition to conducting jury trials, do many of the same things that the judges in General Sessions Court do. They conduct bail hearings. If somebody's been brought in on an indictment, they can't make the bail, or if the defendant couldn't make the bail that was set by the General Sessions judge, they can ask the criminal court judge to review bail. These judges also conduct probation violations. They can do bench trials where they decide if somebody is guilty or not guilty of the charge. And they often preside over hearings about evidence issues, like, did the police illegally search me? And so therefore the evidence against me should not be allowed to be used in court. So those are the things that the judges in criminal court do. We are not going to talk about appeals because that is an even higher level of court that doesn't involve the current elections. But as you can tell, this funnel is accurate in that very few cases go on appeal. So if a criminal court handles, say, 2,000 cases in a year, I would say probably less than 100 of those are filed for appeals. There are appeals filed. So it kind of funnels down. The last level of court that I would reference is juvenile court. So we have one juvenile court judge, and juvenile court is kind of a world unto itself, but it ties into criminal courts in a specific way. So the juvenile court handles all cases and all matters involving children, including what we call delinquency matters. And that's kind of the analog or the same thing as a criminal charge, except we don't refer to children and youth as criminals. We don't use that language in a juvenile court. In that court, we refer to it as delinquency charges. The reason that it can play into criminal courts is that if a child or youth is charged with a serious enough offense, the state of Tennessee can ask the juvenile court judge to transfer that youth to adult court to be tried as an adult. When that happens and the judge transfers the case, it goes from juvenile court into the criminal courts, and then those criminal court judges preside over those cases. So there is the idea of how courts work in theory. And this picture on the left of a courtroom is, my sense is that a lot of people think a lot of cases go to trial, and that most cases are resolved in that way. If anybody thinks that is not actually true. Very few cases go to trial. And this picture on the right is the example, or I guess the analogy that I often use to explain how I perceive the criminal legal system is working. If anybody's familiar with the show I Love Lucy, and this episode in which Lucy and Ethel are working on the conveyor belt at the chocolate factory, our criminal legal system today operates very much like a conveyor belt of processing people. And so, what we see in that episode is that the conveyor belt starts off at a certain pace and then it speeds up, and Lucy and Ethel cannot keep up. And as a result, the chocolates on the line don't get the kind of attention that they deserve, number one. And number two, some of them become casualties of that conveyor belt. So that really is the realities of the way the criminal legal system works today, is that the system is overwhelmed with cases. It's gotten better in recent years than it was, say, 8 or 10 years ago. But it is still overwhelmed and under-resourced. And as a result, the typical processing of cases and people is in the criminal legal system really is about processing, not so much about individualized attention on cases. And I think that that's part of the problem that we have, or one of the problems that we have in today's legal system. So I'm going to try to talk some about realities for the rest of this. So if you want to understand a criminal court, this is a good diagram of who you would see in most courtrooms if you went into court today. If you went to Courtwatch and wanted to see who was there, you would see a judge, you would see prosecutors or defense attorneys, prosecutors and defense attorneys. So I want to talk briefly about the prosecutors and district attorneys, because they are, the district attorney's office is on the ballot this year as well. So they serve 8 years. They are lawyers who are elected, and they are arguably the most powerful person in the courtroom. And the reason I say that is that they touch every criminal case in the criminal legal system. They establish the priorities for prosecution and what policies they'll operate their office by. District attorneys are supposed to, their role is to promote fairness, truth, and justice. It is not to win a case, but to pursue justice. In terms of the power that a district attorney holds and the assistant district attorneys who work for them hold, is almost complete in discretion. Discretion on whether to even prosecute a person for a crime. If they are prosecuted, the complete discretion virtually to decide what to prosecute them for. And then near complete discretion about how to settle a case, whether to offer a plea bargain, if a plea bargain is offered, what that will be, whether to pursue a trial or dismiss a case. So there is a huge amount of power and discretion that district attorneys exercise. On the other side of the courtroom, you have defense attorneys, and there's 3 different kinds of defense attorneys. I'm not going to get into this here, but there are lawyers who you hire. You can hire a lawyer to represent you if you have the means to do that. There is a public defender. We elect public defenders in Tennessee. The Nashville public defender has a 4-year term. And then there are appointed lawyers who take cases that the public defender can't take, and they are paid by the state of Tennessee. Judges choose those lawyers when the public defender's office doesn't take the case. And of course, defense lawyers, their job is to advocate for their clients. They investigate the case, they research the law, they communicate with their clients. And ultimately, it's their job to, in an adversarial system, go up against the prosecutor and try to get the best outcome possible for their client. So keeping up with the judges. That's probably the most often question I get asked is I see all these signs for judges and I don't know like what's the difference between Division 5 and Division 10 and criminal court and sessions. So let me just say this. There are 11 general sessions judges. They are all up for re-election this year. All 11 of those judges handle both criminal and civil cases. They are divided up by divisions 1 through 11. There's nothing magical about the numbers. It's just a way to sort of identify the different divisions of court. They all generally do the same work. Some of these judges have specialty treatment courts, like a mental health court or a veterans court or something like that. And so you would need to know specifically which divisions those are. But overall, 11 seats, 11 courtrooms, 11 different judges. They also supervise 5 full-time magistrates who work at night court. So that's part of their job. In criminal court, we have 6 criminal court judges. Again, they're labeled divisions 1 through 6. There's nothing special about the numbers. It just designates which courtroom they're in. These judges handle only criminal cases. They do not do any civil cases. You will also see on the ballot this year in signs out in yards, you will see 8 circuit court judges. There are circuit court judge races, there are chancellor races. So those are also on the ballot. People are running for those seats. I'm not talking about those this evening because they are not involved in criminal cases. And then of course we have 1 juvenile court judge who supervises actually 9 magistrates who work under her authority and hear cases. And if litigants don't like the outcome of those cases, then they can ask the juvenile court judge to review it. So juvenile court is a very big court with a lot of work going on. And so those magistrates do a lot of that very detailed casework. So the main job of judges, as I see it, are 3 things. They are deciders, like referees. They are administrators of the court system, kind of like conductors of orchestras. And they are public servants. And all of those roles, they have very important things to do. So as referees or as deciders, their job is to listen to evidence, decide what they believe the facts are, and apply the law. And they're supposed to do that fairly and impartially. So that's basically how judges, like one of their main roles. So in a trial, where is the person guilty or not guilty? They decide that. In the context of bail, a judge decides, should I set money bail or should I release this person on pretrial release without having to pay money? Should I set conditions of bail? Should I keep this person in jail? They are deciding these issues. They decide sentencing issues very often. What's the proper sentence for this case, for this person, for this crime? And then they decide evidentiary things like, did the police illegally search this person? So one of their jobs is to serve as a decider of issues that are contested. They also administer their courts. There's a high volume of cases that go through these courts. So judges are responsible for setting dockets, scheduling trials, making sure that cases don't sit for too long, deciding on whether to grant continuance of cases, deciding who to appoint if a person isn't going to be represented by the public defender and can't afford to hire a lawyer. So there's the whole administrative aspect of running a court and handling cases in an efficient way, and judges have to do that. The third thing I would say that I see as the role of the judge is to be a public servant. They are the face of our court system, to be treating participants fairly. They're supposed to avoid conflicts of interest, right? So they wouldn't serve in a case where perhaps a family member is a party, as a litigant. They're supposed to be good stewards of public resources and they are available to their constituents, the people who elect them. They hold open court. They allow people to come in and see. They are transparent in what they're doing. That's what we expect of public servants. So those are the basic roles that judges serve in our court system. So the last question that I want to address before I turn it over to the others to talk about their experiences and about bail. The other question I get asked oftentimes is not like, what is Division I versus Division III, but how do I decide which candidate to vote for? How do I decide, like they all seem the same to me. They're just names and I don't know. And I think the best thing people can do to try to help themselves, to educate themselves about these judicial candidates is ask questions, attend forums like candidate forums, but asking questions. And to me, the most important thing that you could learn about somebody is what they believe the primary purpose of the criminal legal system is. Because when you can identify somebody's philosophy, somebody's values, what they think the court system, the criminal legal system is designed to do, you can then start to judge or ask questions. Well, how will your lens that you bring to the bench impact the way you do your job? So I've listed here common schools of thought really around purposes of the criminal legal system. So there are many people who believe it's primarily to punish, right? We enforce the laws, we find the people who broke the laws and we punish them. And the goal is to stop them from doing it again and stop others. Other people feel like the purpose of the system should be to try to repair harm. When we in a society harm each other, that the court system should be about how do we repair the harm and support people so that they don't harm others again. Support people who are harmed so that they can feel whole again, if possible. Another common purpose that people espouse is to maintain public safety, that our criminal legal system is to keep people safe from violence, to protect property, and to maintain order and respect for the law. Others view the criminal legal system as a system primarily of oppression, that it is a system designed to maintain legal control over certain people, to exploit certain people, traditionally African Americans, traditionally people of color and poor people, and to protect and uphold entrenched power structures. Some people believe the purpose is to rehabilitate, that the people who commit crimes often have problems, they need to be fixed. And if we just fix their problems, then that will eliminate or reduce criminal behavior. And then lastly, to provide a fair process. That the courts they are an adversarial system in our country. That means two sides going contesting each other. But the court system is designed to treat everyone fairly so that we can determine guilt or innocence of crimes and determine the appropriate punishment, and that should be done by a neutral and impartial judge. If you can get somebody to identify what they see as their primary understanding of what the criminal legal system is, then you can start to I think, assess how they will make decisions around the important issues that we face today. Those issues are around jails and prisons, right? Who we send to jail, why people are in our jails. Do we believe jails work? Do we believe prisons work? There are issues around racial justice. And is our criminal legal system biased? And what do judges or candidates see as biased? And what are they doing to push back against that or to reduce those biases in our courts? Class and wealth disparities. How does access to wealth result in people being treated differently or the same? And what are judges doing about that? Do they see a problem there? And if they do, what are they doing about it? And then resources and efficiency. Do these judges believe that the court system is in fact the way to address the problems that we see in our criminal legal system? Most of the problems that wind up in our criminal legal system are the result of other broken systems, in my opinion. What leads people into this system is broken education systems, poverty, over policing, a lack of access to mental health treatment, lack of access to substance abuse treatment, lack of access to medical care. So all of these social problems today wind up in our criminal legal system. And it is judges who are largely dealing with them. And that's why this forum and these elections are so, so important in how we as a city treat people who are here and what we as a city want for our justice system. So with that, I am done. I will stop my screen share.
Dawn, thank you very much for that. I do see that some questions are going into the chat, and that's great. Remember to identify who you want to direct a question to. We will have time for those once we've heard from Courtney, Erica, and Reggie. Next up is Courtney Teasley. And just as a reminder, she's a criminal defense attorney, and she's going to reflect on the reality of the criminal justice system and how the system works and how it impacts the people that go through it. So, Courtney.
Hey, how are you all? I'm so happy to be here, and I actually have been talking to multiple people, and the biggest thing that I've been hearing is that people have never seen so many people come, turn out, and run against these judges that are currently sitting there. I'm talking about it's record numbers of lawyers standing up and saying enough is enough. I was looking through the MLK 50 Justice Through Journalism site, and it said that 8 years gives you a long time to do damage, or it gives you a long time to do good. And so here in Tennessee, we have, our judges have, and our prosecutors have 8 years to sit there. And what I found is that with that being such a long period of time, there's no incentive to be kind or fair or do all the little things that you claim you're going to do while you're campaigning until a year before elections, right? Because people normally have a short memory. 8 years rolls around and you may not even remember who your judge was when you were in front of them. But Maya Angelou said something very, very, that has always stuck with me. And it's, I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel. And so my experience in the criminal justice system here in Nashville, and the courts, a big thing in general sessions that you'll start off with, you'll kind of, and actually it's not just general sessions, through all the courts, you'll see that a lot of time, that people who are alleged of having committed a crime, they're treated as if they are guilty, even though the judges should have the best understanding of innocence until proven guilty, right? And so some people are held over it. There's certain, if you go into general sessions, there's a seat over there where if you got a warrant out for you and you're going into custody, they put you right by the door to go into the back. I've seen people come in late, and a judge, I have them come sit over there and put them in custody or for being late. Or if they have previously said, oh, I'm going to retain a lawyer, when you're asked, do you need a lawyer or whatnot, or can you afford a lawyer? Sometimes people think they can afford lawyers, and then you get to calling around and find out, oh, I don't have that much money. But then you go back to the same judge, and that judge is like, well, what happened? You said you were going to hire a lawyer, A, B, C, D, E, F, G. So I've seen I've seen actual judges berate a person alleged of committing a crime because they couldn't afford the lawyer they thought they could, instead of just giving them the form to fill out and say, hey, okay, look, you got a right to have a lawyer. Let me get one appointed to you. And when we get to the appointed lawyers, the issue then becomes the judge is going to appoint the lawyers that they favor, not necessarily the most qualified, not necessarily anyone that they think can necessarily do a good job, but whoever the judges favor, they appoint those lawyers. I've seen them appoint lawyers that I know for a fact have used racial slurs against people alleged with a crime. That is an issue. I've heard judges yell at people alleged with crimes during docket call by the way, during the docket call, when you're going through calling the docket and someone maybe talking too low, and it's like, speak up. And it's like, oh my gosh, this going to court is not always the normal for everyone. People are nervous. They don't know what's going to happen. They're scared. They don't know if they're going to jail. And it's not always a pleasant experience. An issue I found with a lot of the judges, especially, well, in general sessions, is sometimes you'll have someone who does not have they don't have a lawyer yet or whatnot, or they come on their own, and we're sitting here and they're saying, hey, what can I do? This person's not here, the victim's not here, what do I do? Well, then a lot of times the judges will just keep giving continuances to the state as they ask for them, instead of actually this person has been here multiple times. And even if they have a lawyer and they ask, hey, well, this case, we need to dismiss this failure to prosecute. You know, my client's been coming back and forth. Oh, I'm gonna give the state one more time. So the issue is deferring to the state, deferring to whatever the state needs versus the actual person who's in front of you, who is missing work, who sat there all day through the docket call. And maybe you came on the bench late and they sat there through that. And then maybe you took a break that was long and they sat through that. You had a meeting and they sat through that. And now you're going to tell them that they have to come back again and do it all again, as if it's not a big deal for that person. You know, oh, you should have never been charged with a crime. Well, that's not their fault. The police charged them with a crime, or the state brought charges against them, right? And they are innocent until proven guilty. So the biggest thing that I see is that some of these judges, in my opinion, forget that this is the community. These are people who are charged with something, not necessarily having done that, but they are alleged to have done that. So I see in general sessions, an issue that really plagues that, and I think a lot of criminal defense attorneys fight about and kind of argue about, is that some judges, maybe they don't know or whatnot, but they have the power to address big issues there. If a stop is unconstitutional, that judge can suppress it right there. They have the ability to do that, but when sometimes you call upon these judges to make that decision, to use their power, they won't do it. Or if they have a case and its probable cause is not met, they're like, oh, well, apologizing to the state. Well, you guys can just indict it or whatnot. I feel like it's a bromance or a cronies relationship when you are dealing with the judges, because yes, the judges are paid very handsomely by the state, and the prosecutors are too. And so when you have a person alleged of a crime coming in and you have their lawyer coming in saying, hey, judge, that probable cause hasn't been met here, or there's a clear violation that happened here, judge, you got to, dismiss this, or even bring the judge's case law. Oh, well, it's just probable cause. I'm going to bind it over to the grand jury. Well, no, it's not just probable cause. It is increased court costs. It is increased lawyer fees. It is missing extra work. It is having a charge pending on your record for a longer period of time. This is someone's life. And this is what the judges have to understand, that you are dealing with people's lives. And I don't care if you see the district attorneys or whoever every single day. You are fair. You are supposed to be fair, impartial, unbiased, and this person is a person. So I feel the judges are usually hesitant to utilize their power to suppress or to resolve usual pretrial motions that can be filed in general sessions, because maybe they don't want to upset the state or something of that nature, which shouldn't even be a factor in their mind. And criminal court have seen oppressive limitations of voir dire during trial, where you can't even really get out anything you have to say because the judge is on you, or complete bullying during trials, refusal to follow the law, or maybe they'll just ask what the state thinks, instead of actually consulting the law themselves, or maybe using law from years ago. Law is something that constantly changes. That's why lawyers practice, judges practice. So they have to stay up to date on new laws. They cannot just take it at face value, or what happened a couple years ago. And so I see that the refusal to reconsider bonds, bond motions after the maybe discovery has finally been done, extra things have been found, and you're renewing the bond motion, and just like, well, I already heard this. Well, that's before discovery. It's before we had any evidence. So I see a lot of that. One of the big things that I do want to talk about, I'm glad Don brought it up and said that the prosecutor is arguably the most powerful person in the world. And I agree, because here it is. Angela Davis said the prosecutors control the entire system. They control the plea bargains. They control the charging. There is absolutely no checks, no balances, no accountability for district attorneys. They can give unreasonable offers. They can withhold evidence. They can lie. They can do whatever it is. However, they are absolutely immune from liability, which means they can't be sued for their decisions as prosecutors, no matter how outrageous their conduct. Let that sit in for a minute. No matter what they do to you, no matter if they give preferential treatment to different lawyers, no matter if they treat you badly because they might not like this person or they don't like this lawyer, no matter what it is they do, there's nothing that can be done. So when you have something of that nature, it falls upon the district attorneys to step in and do their job. The district attorneys that are currently campaigning, it falls on them. The Vera Institute of Justice actually spoke about how they utilize something different. They allowed someone to come in and do data collection and find out, let's see what kind of results are coming. In the Washington Post, the Manhattan DA office granted public access to more than 7 years worth of racial data that the top prosecutor says has informed his approach to criminal justice reform. Imagine that. Imagine that. And he said, I did it as a part of nationwide accountability, because they know that prosecutors do not have any checks and balances. But if you have someone, we can have Code for Nashville here, for instance, to come in, go through the data of your district attorneys, get that data together, and let's look. You have a better understanding of what's going on, what has gone on in terms of the operations of the office. The Manhattan DA's office said, I think it's our job to make those numbers available, and people will make of it what they will. Well, the current administration hadn't done that. The prior administration hasn't done that. So all we can hope for is that the future administration will actually make good on something of that nature to show that true progression, the transparency, the accountability that we are looking for when you get out here and campaign and say, hey, I'm progressive. Well, what does that mean? What are you actually doing? What are you doing? I mean, it's public knowledge. You can go see what the prosecutors make. Go and look which prosecutors get paid the most. You know, this is public knowledge. Which ones hold the best offices? What color? You know, what are these things? And it can't be a lack of, you know, so I say all this to say that the prosecutor's office has the most power. They can decide not to work their case until the last minute. I see it all the time. Night before trial, then the prosecutor's office is going in and they're looking and seeing, oh, my case isn't as good as I thought it was. And maybe the defense attorney has been asking for a reasonable offer or asking to settle this case for something. It's like, oh, no. But weekend before trial, now you're looking and now you're actually focusing on your case. And it's like, oh, it's not as good as I thought it was. Okay, well, let's make a deal. Because now you don't want to go to trial, but this person has sat in jail for over 2 years. That offer is no longer good anymore. You know, it's not a good offer after I've done all this time now. And so that happens more often than not. And there's no way that we can ever do anything about it, because prosecutors can do what they want. So it has to go on the heads of the district attorneys who we elect, who are all up for election. I think these have to be questioned. So like Don said, come to these meetings, come to these forums where they're going to be. Let's ask them, hold them accountable. Other people around the country are doing progressive things. Why can't we? Why can't we? And with that, I am at my time.
Thank you very much, Courtney. we really appreciate that perspective and you sharing that with us. Next up is Erica Perry and Reggie Williams. Erica is the executive director of the Nashville Community Bail Fund, and Reggie is someone who has gone through the court system and the bail system, and they're going to share their experiences.
Thank you so much. Hey, y'all. I'm Erica Perry, A pronouns. I want to say first, happy Black History Month. And also name that I come to you as I think folks were naming their churches, a member of Greater Bethel AME Church, and also a member of the Black National Assembly. I'm a movement lawyer that has supported organizations who are organizing to end bail and pretrial detention throughout the country, and working to invest in community needs and divest from cops, courts, and cages. I also work as the executive director of the Bail Fund. And excuse me, I also want to shout out Reggie Williams, who is with us, who will speak after me, so I won't take up too much time, but Reggie is our Bail Fund coordinator who works every day to get people out of jail and out of pretrial detention. And so I don't want to take up too much time, but I really want to frame and add on to what has been mentioned and talk about some of the issues inside the criminal legal system, the role that judges and the district attorney play in that, and then name some solutions and maybe a path forward. And so we think about, from my studies and my work over the past, few years, maybe 6 or 7, I know that bail and pretrial detention are rooted in anti-Blackness and classism, right? We see that both in the practice, but also in the data and who is most impacted by it. And while the idea is to make sure people make it back to court, it costs our families and communities so much. And so a lot of the conversations around bail reform, and as we get into speaking to candidates, judicial candidates and the district attorneys, we want to think about the role that judges and the district attorney play and how much discretion they have over community members' lives. And I think name the issue of over-reliance on judges, the district attorney, and the entire criminal legal system to address social issues. And so I think about some of the solutions to the number of people who are right now in jail because maybe they don't have $100. We have literally bailed people out of jail because they don't have $100 or $250. And I might add that it's a little bit insidious to give somebody a bail for $100. You might as well just let them out, release them on their own recognizance. And so I think about one of the requests that we have with candidates is really encouraging them to increase their reliance on releasing people on their own recognizance and pretrial release. And so the other thing I want to propose for folks who are interested in criminal justice reform and the role that judges and the district attorney can play in that. And so first, community-driven public safety and any reform has to be driven by people most impacted. And so it's important for us to talk to people who, as Courtney named, are sitting in court on a regular basis, right? Or at least until the end of their case, waiting to listen to a judge, waiting for their case to be disposed of, and ask them, what has been your experience and what would a solution look like to that? And their families, because oftentimes we know that if the bail fund can't pay their bail because it's it's over our limit or they don't know about us, it's their family members who are bearing the cost of trying to get them out of jail. And so just a few things. When we think about promises from candidates or conversations with judges around addressing the issue of bail and pretrial detention, I think it's important that we avoid bail reform, any type of bail reform that re-entrenches the current power structure, right? And we want to avoid things that give more power to judges and district attorneys to make decisions, right? And taking those decisions away from families and communities most impacted. So right now we know that judges decide like how long you stay in jail, right? They decide how long a person may be sentenced. They decide whether to RR a person, and they may use a schedule, right? But it's still up to their discretion. And so we want to think about solutions that give more power to communities and families to engage in community accountability and community care. The other thing is we want to avoid trusting judicial candidates that will not commit to accountability and co-governance with Black communities and other communities of color that are most impacted by over-reliance on bail, jails, police, and pretrial detention. And I say that because as Courtney mentioned, there are organizations, and maybe we might even look to Larry Krasner, right, in Philadelphia, who are trying to practice co-governance, attempting to work with community groups to hold themselves accountable. And we want judges and a district attorney who was open to working with community members to mitigate the harm of the criminal legal system. The other thing I think that's important is it's important to ask candidates how they will address racial disparities in the criminal legal system, both as it concerns policing, bail, pretrial detention, prosecution, and sentencing. And although I know policing isn't directly an issue they work on, but I know that judges and district attorneys sit on different commissions and task force and have weight that they can bear to address some of these issues. And now thinking about what are we for? What do we want to happen? And so just to name, some of the solutions that I'm naming come from our work with the Black National Assembly, where we've worked with community members most impacted to really surface solutions, and also my work with organizers throughout the country to think about solutions to bail and pretrial detention. And so it's important that we trust community members, like I said, and I can say it again and again, trust community members most impacted to lead the work and hold elected officials accountable for policies and procedures that actually foster public safety. And this can look like, some solutions might look like ending pretrial detention and money bail, electronic shackling, and then unnecessary, burdensome, restrictive, and often impossible conditions as a condition of pretrial detention. And so that's just conditions of pretrial detention. We haven't even discussed probation and how faulty it is for so many people to be on probation, how easy it is to catch a probation violation and be rearrested and put back in jail. We also want to ensure that people have what they need to get back to court. And so oftentimes we know that many times if people have transportation, if they have access to a phone and text reminders, they likely make it back to court. And being able to forgive people if they can't make it back to court. It's so easy to get an FTA and a warrant, and FTA is a failure to appear, and a warrant for your arrest for missing court. And people miss court because they're sick, they're in the hospital, especially as we're experiencing COVID. And we need to be encouraging judges in the district attorney's office to extend grace to people if they fail to come to court. We also want to, and this is my favorite, invest, divest, which if I had time, I would do a whole training on it. But we want to be thinking about redirecting funds used to incarcerate people in pretrial detention, and redirect those funds to addressing community conditions, right, that lead to contact. And we know that it is possible to significantly reduce the amount of people who are held in pretrial detention, right? And think about innovative ways like text reminders, court reminders, community care to make sure people get back to court. But use those savings, that money that we save, to invest in community-driven social services. The other thing I want to name is, and I said it before, but it's really important that we start to have a real conversation about reducing racial disparities throughout the entire criminal legal system. And I encourage candidates to make sure that is a part of the work they commit to do, and that we as organizers and activists and advocates hold them accountable to that. And so any reform that we should support must address the long history of racial disparities in the criminal legal system and work to reverse them. And so I just don't know how we can support anybody who isn't committed to that, especially in this time when we know so much about those disparities. And then again, the other thing that feels important is ensure clear and transparent enforcement mechanisms as it concerns reforms. And we want to make sure that we have access to data. As a lawyer, as an organizer, it is sometimes difficult to access data inside the criminal legal system, which means that we are not able to get the full story. And so we want to make sure there's a spirit of transparency. Again, and that goes along with co-governance. And we can get into it. We know we want to eliminate fines and fees, right? Including costs imposed in connection with pretrial conditions of release. And so those are a few things that we can start doing and thinking about as we really prepare to think about the role of judges in the district attorney's office in our quest to have true, safe communities and just communities. And so I want to pass it to Reggie now. Thank y'all so much.
Thank you for having me. My name is Reggie Williams. I am the bail coordinator at the Nashville Community Bail Fund. I am working directly with Erica Perry and Cyrus Wilson to make sure that we can reunite participants with their families. So I'd just like to take this time to just thank all of the panelists that have spoken before me. It was just, I was just in awe of just listening. I can listen to y'all for a while. I mean, so you were great. But I just wanted to give you a picture of what the ground level looks like when dealing with the bails in pretrial detention. So from day one for those participants, people that go through pretrial detention and trying to be released from jail, staying in could cost them their job or their children or home or even their health. These are things we've seen that directly impacts them dealing with pretrial detention. And what we've seen is when judges and district attorneys work together to keep participants in pretrial detention, it makes it more difficult for them to fight their case with their lawyer to come to a best outcome, right? Because that is what we want as public, individuals. We want to make sure, that the process works, right? So as of last year, 2021, the National Community Bail Fund bailed out over 300 participants. Since conception, we've bailed out over 1,600 individuals, right? And many of those people, those cases have resulted in a dismissal or a not guilty plea. I'm not guilty.
Could you be quiet, please?
This is important to note because the outcome could be different had those individuals not made bond, right? So unfortunately, what we see is the judges that are currently in the seats, they make decisions on the participants and their bail without taking into consideration their ability to pay the bail, right? And most of the time, what it costs their families to pay these bills, right? And then Davidson County Jail, as someone has said, I have been one of those individuals that have experienced the system. And by the grace of God, at 19, I made some mistakes that cost me some time of my life. But by the grace of God, I was able to put things back together and become an advocate for those that are going through the system and fighting to put their life back in order, right? So the jail is a horrible place, especially during COVID, because we've seen that these individuals are in the detention center under the unlikeliest conditions, be it that they have health conditions. A lot of them are immunocompromised or, and as you know, when they're packed in these tight places, communicability is high, right? So this poses a problem for those that are older and those that are vulnerable to any health issues. And it's clear that the judge has no consideration of those participants and their conditions, right? So what we found that is most important is we need judges that care about our humanity, right? And many of those judges that lord over the participants or those individuals that are fighting for their freedom, these judges do not take in consideration whether these individuals that are paying bail or trying to receive bail are guilty or not, or even their family conditions or their life conditions or their health conditions. And so the truth is the system is built around racism and classism. And those individuals that are going through the system usually pay the ultimate price. So what we found also is that the judges and district attorneys that treat people or accuse these individuals are more likely to pass judgment without taking into consideration each individual case, because each case is different, right? Each person, their experience or the factors in their case is different. So the Nashville Community Bail Fund exists to level that playing field, to normalize pretrial detention and bail. And we are passionate about what we do. We exist to make sure that the minorities have an equal say and that they get equal opportunity to freedom and reform, right? So I just thank you for your time. Thank you for listening. Thank you for having me. If you have any questions or anything that we could do, reach out to us at the Nashville bailfund.org. Thank you for your time.
Reggie and Erica, thank you so much for your statements and for sharing all of that. We're now going to enter the Q&A portion of this. Jane, do you have any questions that you want to direct to our participants?
I do. Let's start with magistrates. We have a couple different questions about magistrates, and I think Don would be the best person to answer this. One person said, where do magistrates come from? Are they hired? Are they appointed? Are they elected? And just how are they chosen? Don?
So magistrates in General Sessions Court are hired and supervised by the General Sessions judges. They're not elected, but they are hired. They are lawyers. And so those General Sessions judges, as a group of 11, make hiring decisions. And then a small group of, I think, 2 or 3 of the General Sessions judges supervise those magistrates. In juvenile court, the juvenile court judge hires the magistrates and supervises the magistrates. So magistrates are not elected, but are hired and generally supervised by the judges for the court level that they work in.
Okay, thanks. That helps. This is a question for Courtney. Someone asked to explain, what does it mean when you are released on personal recognizance? How does that happen? How does the judge make that decision?
When you're released on your own recognizance?
Yes, ma'am.
Okay, so that's just basically when you're in front, and actually it usually happens when you're with the magistrate that we were talking about. You have the ability, they don't have to take a bond of any kind. You don't have to pay anything. You just sign some paperwork and basically agree to make sure that you come back to court on your court date.
Could you maybe elaborate and talk about how some judges do a risk assessment?
I think Erica will probably be best on that one.
Okay, Erica?
Questions on how judges engage in risk assessment.
Yes, ma'am.
So from my understanding, the judges have a tool that community members were not a part of creating. Just want to name that as a form of bail reform. They developed a tool, which is really just a sheet of paper where they ask a few questions about like the person, that they ask a few questions to determine whether a person is likely to reoffend, likely to come back to court. And so they use those questions to then determine if they release the person on pretrial release or if the person gets a bail. And if so, how much, or if the person is held in preventative detention, or AKA just held in pretrial detention without a bail. But it's also possible for, after that process, for an attorney to still ask for a bond hearing where the attorney can go into a bit more detail to advocate for their client to get a bond reduction or just release without having to pay bail. I think what's important to name is that like risk assessment tools are oftentimes given to us as a form of bail reform, but from my research over the past few years, it actually ends up harming Black people and other communities of color more because of the reliance on judicial discretion.
Okay, I think that covers it. That explains it to people. Another question came from someone who wants to know if all Tennessee counties provide 24/7 access to courts like Davidson County does, like a night court. In other words, are there magistrates that would hear a person's situation and assign bail or do some type of leveraging of their situation in other counties besides Davidson County 24/7. Don, maybe.
I don't know. Courtney may know because if she's practiced in other places or if Erica's practiced in other places. I do not believe all counties across the state have a 24/7, 365 night court. And that some people stay in custody several days sometimes just waiting to see a magistrate about a bail hearing.
I guess chiming in on that, I'm not 100%, but I do know other counties sometimes just totally disregard, what the law is, even, having a hearing within 14 days if you're in custody. I know one particular county doesn't do that at all. So I can't speak to whether or not they have 24/7 magistrates.
And one of the other questions, and each of you can chime in on this, people want to know, several people wanted to know, what's the best way for a voter to check on a candidate's history? If they've been a judge, what can you do to find out what their record is? If they're a candidate running against an incumbent judge, what kinds of questions can you ask a candidate who is running, how they would do things differently in the court system? What is their preference for having their court system or their courtroom operated differently? What is their system of justice, their philosophy of justice? How do you find that out?
So I'm sure Don can chime in, everybody can chime in after this, but my first, I can speak from what we've attempted to do. We have, as a legal redress chair, we have tried to get information from the clerk's office, and we had a ton of roadblocks. We wanted to put together data for the community just for this, just like Harris County, Texas does. And we had tons of roadblocks, and and I think that's an issue we have to really explore with the clerks, because Davidson County is not very transparent with that data. And all of the data from the CJIS website that's online is not all the way, it's not up to date. And everything is not there, is not listed there. So that's one issue we ran into. So I would say the best way for you to check on the judges that are already in office, why don't you do a Google search of them and just see what they've been into or whatever has happened within that time frame. You can go to some of these different organizations or reach out to the different organizations and inquire about complaints. You can go to the Board of Professional Responsibility and look into complaints. Obviously, if you just go and hear them now, they're going to be talking about everything great that they do. I'm fair, I'm this, I'm that, I'm this. But to be short, there's absolutely no place where you can just have all the data on that candidate and what they did for the entire 8 years. Isn't that crazy? Which is why we tried to get the data, but it's been very hard, even though it's public. So it's supposed to be public. However, as for the people coming in, you have to just look at their history. You can go to their sites and look at their campaigning and see what their platforms are going to be. But I just think that you need to confront them with some of those things that you did not like that the other judges did, or the things that we've been talking about that we hate, and the things that are so hurtful and whatnot. And let's commit them to this information. Let's commit them to their responses at this point in time. We have the biggest amount of people running right now. And so that says something. And I think now is the time for us to start keeping a tally on any judge that gets in office. 8 years is too long for you to go without accountability, And so that's my 2 cents on how to get started.
I think I'll just make a little plug for our upcoming candidate forum nights. We will be having 4 different candidate nights. We'll be having 2 for general sessions, because there's so many general sessions candidates. We'll be having a 3rd one for the criminal courts and a 4th one for the DA. So if you have registered for the webinar you're watching now, you'll be on our list to get information and a flyer about the other upcoming webinars. And I'll turn it back to David now.
Great. So are there no more questions, Jane, that you wanted to that we needed to hit. We do still have time for the Q&A.
A lot of them have to do with how you find out information about candidates. And that's why I just summarized.
Okay.
Somebody asked if you can do a public records search. But I think Don said, doing a Google search is good. Coming to the forums that we're going to have in March would be good. You do have to do a little homework.
Yeah,
Go ahead.
if it's possible, I guess what I wanted to add, if I could, is it's extremely hard to get information about judges in Davidson County, despite the fact that Davidson County has a pretty sophisticated, the clerk's office, criminal court clerk's office has a pretty sophisticated data system. It still remains hard to get data about particular judges, especially in General Sessions Court, because as I mentioned, those judges rotate week to week to different courtrooms. And so if, for instance, if one judge is on what we call the jail docket this week, where all the defendants are in jail and charged with a felony, next week they're going to rotate off that docket and another judge will be there. And so that the judge there next week may hear some of the same cases back that were on this week's docket. And so you've got judges rotating and touching cases, so there's no real true ownership of cases. Criminal court is a little easier to get data because those judges essentially keep control of the same cases. Davidson County has an office called the Criminal Justice Planning Unit that produces all kinds of data reports about the criminal legal system. And for criminal court judges, those 6 divisions, you can get data reports that will give you information about like how many cases went through that court system, went through that particular judge's courtroom. And you could get factual information, but it doesn't really tell you much about how the judge is deciding things, right? Or what the judge is doing. So for instance, it's very hard to find, there's maybe 1,000 people in the jail right now, 1,000 to 1,100 people in Davidson County Jail on the average night. It would be great if we could get a breakdown of which judges are responsible for how many of those people being in jail, right? So that would be something that we would want to look at. It would be great if the clerk's office could produce a report for these judges around how many bail motions did they hear, and how did they decide those cases, right? Did they grant a bail reduction or did they leave the bail amount the same? But that's impossible to get right now. The kinds of decisions and particular data points that I think you need to be thinking about are some of the same subjects we've been talking about here, right? How are bail decisions made? Are judges waiving court costs and fines and fees for people who can't afford to pay them? Or are they saddling people with court debt and not waiving it? What's the length of time that a person's case remains pending in that judge's courtroom? How many can you look at the judgments from that courtroom to see how many people from that courtroom are being sent to prison as a final case outcome? How many are being placed on probation? How many cases in that courtroom being dismissed? Right? Getting these kinds of substantive data would be terrific, but it's virtually impossible. Unfortunately, a little easier for criminal court, but very hard as a regular citizen. Frankly, it's hard sometimes for even somebody who knows the system pretty well to get that data. As a regular citizen, it's really hard. And so I think candidate forums are important. The other thing I'll say is this: talk to friends who who work in the court system. I think that the reality is that lawyers are hesitant oftentimes to publicly speak out about who they support and who they don't support, because those lawyers have to practice in these courtrooms. And so if I say something negative about a judge on the NOAA forum, that's going to get back to that judge. And then I will potentially suffer the consequences of that. But perhaps what I worry more about is that will be taken out on my clients. That's just a real thing. So that's the other thing I do. Find a friend or a friend of a friend who works in the court system and call them up and ask to have a conversation with them. And that's another way to try to get some good information.
Courtwatch is
it's like-
another, I'm sorry, Courtwatch is another system, another method, I should say, that you can be involved with. You can probably talk with Erica. Erica would know about Courtwatch, Erica and Reggie, right, Erica? You can tell people about how to be involved with Courtwatch.
Actually, what I was going to say, I think Courtwatch is a great idea. But a few things. One, there are folks who actually experience the criminal legal system from the side of like being defendants, who I think also know really well what judges are doing and aren't doing. And so I think one group that I really think about is Free Hearts, who has a participatory defense program where they work with people who are forced to experience the criminal legal system to help them navigate their case. The other thing is the Black National Assembly is having a State of Black National Town Hall where we will lift up some of the data around judges and district attorneys, and also talk about some of those racial disparities that I mentioned, and what both like elected officials on the city council side, but also what judges in the district attorney's office can do to address them. And so I think there are a number of ways for folks to learn, both from like practitioners, people who are practicing law, but also I think it's extremely important that we talk to people and listen to the voices of people who have to walk in those halls, and sit in front of those judges as people who are accused of crime.
Thank you. Go ahead, Dave.
I do see that there's a question directed to Erica and Reggie that says that if we know that bail risk assessments in such things are harmful to people, what's stopping that from being reformed or eliminated?
I think some of I like this question. Some of the things that stopping the bail and risk assessment reform is, I think that we really need to organize our communities to create sustainable and community-driven alternatives to pretrial detention, which I know folks are working on. I think the other thing is that it is profitable to invest in risk assessments. And while I think the Nashville uses a risk assessment tool that is not like, that we haven't purchased, right? I know that other counties have purchased and have contracts with other entities that use risk assessment tools. I think the other issue with the way I've experienced bail reform and how slow paced it has been is that, right, people feel afraid and threatened and want to address harm. And we haven't yet been given like true alternatives or being given the room to experiment with ways to foster safety. Because we know that we've invested billions of dollars in the pretrial detention and police and courts in this city, and people still don't feel safe in some ways. And so I think the work of the National People's Budget Coalition, the Black National Assembly, has been to really foster and work with communities to create sustainable alternatives and invest in those goods, while we, again, work with the bail fund to mitigate some of those harms. But I think that's why it's been a slow roll. And I just really encourage us to work on organizing our communities to address these issues.
Great.
Thank you.
Great. We have a couple minutes, so I'm going to sneak in another question that's probably addressed to Courtney and to Dawn. How can we advocate for more transparency in the court system? And it's probably from the clerks that you're talking about that are generating a lot of the statistical data. But is that something that comes from the Metro Council passing a resolution, or what should we be? Who should we be advocating to?
Our clerks.
Okay.
One thing.
Judges.
The judges, yes, well, but if they demand transparency, then the clerks have to fall in line. But one issue we found was that the data in the clerk site was just inconsistent. Some people the clerks sometimes put in the punishment or whatever happened, or, and some put in the bare minimum. And so it wasn't consistent. And so when we tried to go judge by judge with, the people just for the last year, it was just some clerks do better than others. And then when we tried to get the information, you know, of course, all those fees come. Well, that's a lot of data. This is going to cost A, B, C, D, E, F, G, you know, and we need you to narrow it down and tell it, but we need all the information. We can't narrow it down, you know, so I think we have to really advocate, like Don said, with the judges first, because if they demand that transparency, then the clerks will have to fall in line, but then also with our clerk, and he's been there for a long time. And if we express and the community is saying that this information needs to be done better and you need to be more transparent and make it public for us and more uniform, he's going to have to listen. He's an elected official as well.
That's great. Great. Thank you. Okay, so I'm going to wrap up the Q&A section, and I just have a few concluding remarks and a call to action for you guys, and then I'm going to hand it to Eugene for a benediction. So it has come out just from this discussion. One of the biggest hurdles that people have when these elections come up is that they don't know the candidates, and they don't really know how the people who hold these elected positions affect our own lives. They don't necessarily know the issues that the judges and the DAs deal with. NOAA is going to be running judge and DA forums in March, and that will be a chance to hear from the candidates and ask pointed questions about issues that concern us. Even more importantly, it's a chance to get their commitments to work with us on critical issues that you've heard about tonight. To create change, we have to be in a relationship of accountability with these elected officials, and that dialogue goes a long way to creating that. The candidates have until the end of February to declare. The primary election is the one that we really need to pay attention to, and that's on May 3rd. We encourage all of you to attend the candidate forums that are happening. These elections, well, attend the forums and vote. These elections often have really low turnout, but that means that if you and your friends vote, you can really make a difference. In 2018, one of the elections was won by 2,000 votes. And so if just 1,001 of the votes went the other direction, there would have been a different result. And so the fact that you attendees have made the effort to show up, just know that your vote matters and the votes of your friends. If you're willing to help with the phone bank, we are going to be working with the League of Women Voters in order to stand up a phone bank to generate awareness and attendance for the judge forums. And so in the agenda, we've included the email address of NOAA. It's info@noaatn.org. And send us a note indicating if you're willing to volunteer in our phone bank, or if you want to volunteer in any other way with NOAA. We'll put you in touch with the right people. Finally, these elected positions are critical, and the more we educate ourselves on what they do and what the positions are, the better we can vote. So please watch for announcements for the judicial DA forums in the second half of March, and please plan to claim your own power by voting. So with that, I'm going to turn it over to Eugene to send us home with a benediction.
Thank you, David. And once again, we'd like to thank everyone who participated and thank those of you who were here to take part in this. Let us receive our benediction. May the strength of God sustain us. May the power of God preserve us. May the hand of God protect us. And may the way and will of God direct us. May the love of God go with us, each and every one, from this day forth and forevermore. Amen.
Amen.